Judge Chutkan's gag order coming under a little bit of fire in the Court of Appeals out of the DC Circuit. We're going to go through it today because the audio recordings are available. Isn't that curious? Chutkan and all of the other federal district courts, they really don't want us to hear much about Trump and his trial when it is on display in the 2024 election cycle, but they're talking about today the gag order because Chutkan has said that Donald Trump can't talk about the case. He posts stuff on Truth Social. It's very offensive to Jack Smith and those deranged thug prosecutors over there. They're constantly having their feelings hurt. I can't believe what Trump posted on Truth, and sending each other text messages, crying to their spouses and so on. But this is the appeal. Trump says, I can say that stuff, okay? This is free speech in America, and if I've got criticisms against the DOJ, that's part of my free speech, first of all, and it's part of my political campaign, which is court-protected political speech protected under the First Amendment. So today, we're going to go through several excerpts, and some quite long, of the proceedings in the DC Circuit because they are quite good. Now, I want to introduce you to the people and the parties who are joining us to debate this gag order. And ultimately, I want to make the point that I think that this is just a temporary pause. Very likely this is going up to the Supreme Court because this is the battle between two immovable forces. You've got the justice system, the sanctity of the criminal court, due process of law, and the court's authority to regulate itself versus free speech, political campaign. America's #1 candidate right now, according to polls across the country, who can't talk about his political opponent who is using the Department of Justice, according to our interpretation. You might disagree with that interpretation, but we should be free to make it weaponized DOJ that is going after his political opponents. Now, shouldn't we be able to say that? Here, we're going to be making that argument in front of these individuals. So let's introduce ourselves to the parties. This is the minute entry from the oral arguments on the way to the Supreme Court. This one's coming out of the United States Court of Appeals for the District of Columbia. You see the cases United States of America versus Donald Trump. Trump as the appellant, the person who wants to appeal the gag order. And these are the minutes. Now, it says proclamation being made. The court opened on Monday, November 20th at 9:33 a.m. The cause was heard as case number 1 of 1 and argued before the court by D. John Sauer, counsel for Donald Trump, Cecil V. VanDevender, counsel for the government and the DOJ. Signed off on by the clerk of the court. And you see the judges who are here are Judges Millett, Judges Pillard, and Judge Garcia. And that's who these people are. Judge Millett is an Obama appointee. We'll be hearing from her. And you can put names to faces. I think you'll be able to see who is who. We got Judge Millett. We've also got Judge Pillard. We also got this one from Judge Garcia. Judge Garcia is a Biden appointee, and both of the other judges are Obama appointees. And you might say, oh, great, what's this going to sound like? And, you know, it wasn't as bad as you might expect because the First Amendment is kind of hard to dump all over because it's kind of, you know, the First Amendment. It's the first one, and it's pretty clear. But we're going to see how this all unfolds. Now, first up, as the party doing the appeal is Trump and Trump's defense in this case. It is D. John Sauer who's going to be arguing. We haven't heard from him in the lower level, but appeal lawyers, you know, appellate lawyers are different, a different breed for sure. And so they brought him in to argue this, and this is what it sounds like. Now we're going to listen to 2 clips from him, and then we're going to turn it over to the government. Okay, we've got 2 more clips from the government. And so just for even time, I'm trying to keep the clips about even and also show both opening statements. But here, I wanted to just pause and say that the Court of Appeals, they're pretty aggressive at appellate level. And the reason for that is because they got to tease through these issues. If we're on the way to the Supreme Court, they got to really unpack everything. And so when you hear these arguments, you're going to hear the judges are kind of attacking both sides. They're pretty aggressive with both sides. They're kind of in a position of ultimate skepticism. Oh, you say all this is true? Well, what if I change these variables? What if you're saying Trump has free speech, but does he have free speech about this, that, and this? And you, like strings on a guitar, you pull on the different variables and you whang, and you see if they, you know, really reverberate, because sometimes you might pull on a string in a case and it might not matter. Like, does Trump's free speech matter if it is election season or not? Or does he just have free speech? Because if it matters during the free speech, like if it's amplified during the election season, is it about the election or is it about the free speech? We want to disambiguate all the different things that are happening. And so let's jump in and listen to what happened when D. John Sauer, Trump's attorney, started out his argument in court in the DC Circuit Court of Appeals.
Thank you, Your Honor, and may it please the court. John Sauer appearing on behalf of the appellant, President Donald J. Trump. Gag order in this case installs a single federal district judge as a filter for core political speech between a leading presidential candidate and virtually every American voter in the United States at the very height of a presidential campaign. The order is unprecedented, and it sets a terrible precedent for future restrictions on core political speech. The Supreme Court said in Republican Party of Minnesota against White that we have, quote, never allowed the government to prohibit candidates from communicating relevant information to voters, and it's not the role of the government to dictate what topics are appropriate or necessary to discuss in the context of a political campaign. The gag order does both of those things. Cases involving gag orders imposed on criminal defendants who are political candidates, the Brown and Ford decisions, have both given, in the words of Brown, the candidate, quote, absolute freedom, virtually unrestricted ability to comment on both the case in front of him and make public statements that relate to his campaign as it relates to the case. So this is a radical departure from the only cases that have considered this particular form of restriction, a restriction on a criminal defendant who is also campaigning for public office. And it does so in the context of a hotly contested campaign for the highest office in the United States of America. In addition, the gag order, another unprecedented break with jurisprudence, relies completely on an insupportable heckler's veto theory. The gag order does not say, hey, your statements are going to poison the jury pool by communicating directly with the members of the jury pool. What you have here is a rationale that says this speech, the speech that is targeted by the gag order, might, there's no evidence of this, but it might someday inspire some random third party to engage in some action that might result in harassment or threats to witnesses. This is a quintessential heckler's veto, which the Supreme Court has not traditionally subjected to scrutiny, even very strict scrutiny, but that is just categorically unconstitutional. And the reasons for that, if you look at the heckler's veto cases, in virtually every case, the argument justifying the heckler's veto is we have an absolutely compelling reason to do this, because the speech that we want to suppress is going to inspire rioting, violence, injury, death, whatever it is. And the Supreme Court has said again and again, you cannot do that. All the gag order cases relied on the government do not address this particular heckler's veto kind of rationale for criminalizing speech. And the Supreme Court has held us again and again that that is not a permissible rationale to silence anyone. Those cases go back decades, and that government rationale goes back to at least the city of New York in the 1860s.
Would your position be any different if the timing were just a year ago? So we're much further removed from a political campaign. Would your position be the same or different?
Certainly a year ago, we would still be in the midst of a political campaign. I believe President Trump...
When are we not in a political campaign?
Okay. I mean, I fight the hypothetical, but if you're saying that it was made at
a year ago, if it was a year ago,
right,
if it was last November.
At a time when he was not a presidential candidate, all the other rationales...
But certainly still engaged in political speech.
Absolutely, core political speech.
So would your position be any different a year ago?
I think the gag order would still be unconstitutional.
Would your position be any different?
I don't see how it would.
Okay, so the fact that we have a campaign going on does not matter. What matters to you, and this is still political speech, which gets very high protection, no doubt.
I wouldn't put it that way. I think that the fact that the campaign, in other words, we have a whole series of...
Your position would be no different if it were a year ago.
Our position would be that it's still unconstitutional, but the campaign adds additional and very powerful reason why it is unconstitutional.
But it's icing on the cake as far as you're concerned. Your position would be exactly the same without a political campaign.
I would say it's the crown jewel of a series of at least 7 fundamental precepts.
You need a crown jewel? You think the outcome?
No, you don't need a crown jewel. You just need free speech, right? He's correctly, I think, going back to the base layer of free speech, but when it is a campaign issue, it elevates that because it's political speech is the core of what we're trying to protect here. It's a redressing your government, right? Petitioning your government for a redress of grievances because the current people in power have been corrupted. They are stopping the proper functioning of government. You have to be able to speak out about that because you only have speech. They control the levers of power. And so I know the audio is a little bit fast here. This is their just starting here, so everybody's all jacked up and talking really fast, but they're going to slow back down a little bit once the tension leaves the room. So this is more.
Outcome should be exactly the same whether or not there's a political campaign underway.
Yes, I believe there are at least 7 independent First Amendment precepts that are violated by this gag order. Campaign speech is one of them. Heckler's veto is another one. So, for example, a year ago, we would still, if we had the same gag order, we would still be dealing with a categorically invalid Heckler's veto type theory. We would still be dealing with core political speech. Again, we would still be dealing with a situation where we have a restriction on criticism of public figures. That violates the whole public figure doctrine. There'd be a whole series of reasons it would still be unconstitutional. However, one of the most powerful and compelling of those, I'm sorry, Your Honor.
So, Mr. Sauer, you point to the fact that your client is in the midst of a campaign, but I trust you agree that a prior restraint, is, no matter to whom it would apply, is subject to the highest level of constitutional scrutiny. That's your argument.
Absolutely. Yes.
So, and I also trust that you agree that your client is not above the law that applies to all other Americans.
He's subject to the First Amendment in principally, but yes.
He's subject to the law that applies to everyone. He's not above the law.
We certainly haven't argued that, Your Honor.
Right. And so the district court found that when the defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. And we view that factual finding for clear error, right?
No, in a First Amendment case, I believe, as we cited in our standard review section under Houston against Hill, the court should engage in a plenary review of the record under de novo review. That is a mixed question of fact and law.
But for the findings about what happened in the world, we look at that for clear error, and then we look at the First Amendment implications de novo.
Looking at that particular...
Okay, so they start getting into some technical stuff. They're basically asking, what are we trying to do here? What kind of standard are we applying to this matter in front of our court right now? Like, what are we talking about here? Because you got to be very careful about that, right? We don't want to spiral off. Like, it sounds like we're spiraling off into a bunch of other hypotheticals and stuff. What if Trump wasn't running last year? What if this case was a year ago? Like, it's going into hypotheticals. But again, she brought it right back down to, well, what are we doing here? Okay, we've got an order. It's a written document from Judge Chutkan, which came back from the lower level district court. And the order says a bunch of stuff. And so specifically, like, we got to go through this order. And what are you arguing about? This paragraph, is that good or is that bad? Is that legal, unconstitutional, limitation on free speech or not? Bit by bit. But also the question is, what rule and what rules and and standards do we use to measure the lower level case? And so they start going back to that. Are we de novo on this? Are we, abuse of discretion? These are the different appellate standards. And so a lot of that is quite technical and boring. And so we'll fast forward through it. Now, one of the biggest issues, and really what I want to spend most of this time talking about, is causation, right? And this heckler's veto concept. The heckler's veto is this idea: somebody's up there speaking, they say something, the person who heard the thing doesn't like them, or they do something that is bad, and the person who said the thing is responsible for that person doing the thing or causing some problem. And that means that if you say anything to somebody in any context and they do something and they point the finger at you, you're responsible for that, even though you have free speech in America and you're allowed to say things. Now, again, if you say something illegal, like if you're threatening or inciting somebody to violence, there's already laws against that. You already can't harass people. You already can't threaten people. You already can't incite a crowd, right? All these types of things. So it's already illegal. But what they're trying to do is gag Trump from talking about stuff that is otherwise protected. And the question is, they're saying there's harm from Trump's speech. We talk about following the bouncing ball on, the kids shows. Dun, 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 dun. Same thing here. If Trump says something or posts something on social media about deranged thugs Jack Smith, or about Molly Gaston, the highlighter queen, or about Jay Bratt, whatever his story is, and other things, can they do that? If Trump says that, does the bouncing ball fall into harm such that the causation exists that Trump can be gagged in violation of his First Amendment rights and our First Amendment rights? And I never want to forget that. We have a right to hear from him about this. Trump is the subject of this. There is no person in America who is better qualified to talk to us, prospective voters, about the corruption and the disgusting behavior from the deranged thugs at the DOJ's Jack Smith office. He can see it firsthand. He's there experiencing it every day. We want to hear from him. And they're saying we can't. That's a violation of our rights. So this is John Sauer, again, back up in the Court of Appeals, having oral arguments with the judges. And here's what it sounds like, talking about causation. How can we blame Trump for certain things?
Every voter in the United States of America.
I do want to get to questions about the scope of what he's able to say, but just briefly back to the evidence. You're certainly correct that most of the threats at issue, this pattern of statements followed by threats, is from 2020. But I think the link might be, and I wonder what your response is, that was all about the same subject matter of this case. So essentially what the district court is finding is we have a past pattern. When the defendant speaks on this subject, threats follow. And now he's making similar statements again. We're months out from the trial. This is predictably going to intensify as well as the threats. And so why isn't the district court justified in taking a proactive measure, not waiting for more and more threats to actually occur and stepping in to protect the integrity of the trial?
There's an evidentiary burden here. The evidence, actually, it isn't just that there's no evidence now. It's that the evidence we have now completely counteracts that inference, because it is undisputed that President Trump has been posting about this case almost incessantly since the day it was filed, and they haven't come forward with a single threat that's even arguably inspired by any of his social media posts. The only threat they talk about in their brief is from the Schrei decision, from the Schrei case from the Southern District of Texas. I strongly invite the court.
Well, counsel, and a death threat to the district court judge in this case.
Right, Abigail Jo Schrei. That is the August 5th telephone call. Southern District of Texas.
The day after he said, if you come after me, I'm coming after you, that threat issued.
I strongly encourage the court to pull both the probable cause statement and the detention order from that case, where there's evidence that particular threatener, there's no evidence of any reading of social media. That particular threatener is a unemployed, mentally unstable, heavy alcoholic who sits on her couch drinking beer all day, according to her father, never leaves the apartment, watches the news, not reads things on social media, watches the news on TV, gets angry about it, and makes angry, threatening calls.
I'm sorry, counsel, this might have been partly my...
So that's the threat, right, that they're citing. He says, look, go read the probable cause statement. Those are the documents, the charging documents. This is why we think there's enough here to charge this person with a crime. That person was already charged with a crime. Phone call happened simultaneously to Trump, but they tried to pin it on him. She's just an alcoholic who sits at home, is just angry at people, doesn't even watch social media, watches the news.
But I want to go back. Imagine all we had was the 2020 pattern. That evidence is very specific. It's about when the president speaks on this issue, events around January 6th, and that there are very specific threats that people receive. And again, that was a time where the atmosphere was very tense. As this trial approaches, the atmosphere is going to be increasingly tense. Why does the district court have to wait and see and wait for the threats to come rather than taking a reasonable action in advance?
Again, the standard is imminently impending, solidity of evidence. We have an inference from stuff that happened 3 years ago, countervailed, contradicted by the evidence we actually have here, which is wall to wall. I mean, they are saying, oh, it's an imminent threat that someone could be harassed.
Let me ask you, Mr. Sauer, the conditions of release in this case prohibit your client from communicating about the facts of the case with any individual known to the defendant to be a witness, except through counsel or in the presence of counsel. Your client signed those conditions of release. Counsel before the district court was quite clear that that was not being challenged. How, under your analysis, would those conditions of release not be invalid? Are you taking a position that those conditions of release violate the First Amendment?
No, we have never challenged the conditions of release, and the president has complied with them.
How, under your analysis, would they not be unconstitutional?
Well, a violation of that condition of release may be the response to Judge Millett's question from earlier about about
wondering about
whether
that.
that would be something, for example, that might not be criminal, but would be a clear and present danger to the
That
administration.
would? I don't want mites. I'm really trying to understand your legal test. If he were to pick up the phone and call someone that is known to him
Good questions.
to be a witness, prospective witness in this case, and speak with that person without counsel present, that would violate the restriction undoubtedly. Would the First Amendment protect that communication under your test?
We have not contended that.
It's not what I am asking. I'm asking you to apply the test that you propose us, because we have to write a test that can be applied, and we have to know how it's going to be applied. So I'm asking your position, your legal position. Would that phone call be protected by the First Amendment or not?
Is it a phone call where what's said is Happy Thanksgiving, or is it a phone call where
I'm
it's
not
said,
telling
"I
you
want to
why,
testify,
because
sir"?
the order, the release restriction doesn't care about the content.
Yeah, I
So
don't-
he picks up the phone and calls a witness in direct violation of the terms of release.
We do not contend that that would be
I'm not
protected by the First
contending.
Amendment.
Okay,
It would
so that would
be
not
protected
violate
by-
the First Amendment. That is allowed under the First Amendment.
Yes, that's completely consistent with the positions we've taken in this case.
And now if the next hypothetical is he gets on the phone and he says, X, Ms. X, you've always been someone, courage, backbone, a loyalist, a patriot, and you know, loyalists and patriots don't talk to prosecutors in my case, and hangs up. Okay, if he said that.
I think that would be a clear violation of the terms of release.
Okay.
Also
What if
unprotected
he
by the First
instead gets
Amendment.
on a stage somewhere or on social media and says that exact same thing? Ms. X, a public figure, is being bothered by the prosecutor. But people who are loyal, honest patriots don't talk to the government.
He hasn't said that.
I'm not suggesting he has said that. To be clear for the record, this is a hypothetical question. Does punishing that conduct, because he's not speaking directly to the witness, he's doing this on social media or at a town hall
So the judge is pulling on the guitar strings right now, just to see what resonates.
or a news interview, he says that. Does it violate the First Amendment to say that's prohibited?
If he's communicating with the American electorate about matters
I've
of
told
utmost
you the
consequence,
facts. Okay, so your answer is no.
I'd have to know more about the context of the
Oh,
statement.
I've given you all the context you need to know. If he does it over the phone to the prospective witness, you've said First Amendment prohibits it. If he says it with a megaphone, knowing that witness is in the audience,
Then you're very likely in the same scenario.
okay?
But again,
And if he
I-
does
again,
it on social media, knowing that person's a social media follower of his,
Again, I think you're getting further afield and more into core political
But doesn't
speech.
that
at this
have to be your answer? I mean, Legion are the cases that you have to agree, as you did with Judge Millett. Legion are the cases that say there's no right of a criminal defendant to try his case in the media. That's what the court is for. And of course, what's difficult about this case is that there is some substantive overlap between what the defendant wants to do in campaigning and what prosecution here is doing in the case. But to the extent that there's an ability to distinguish between trying this case in the media and running for president, clearly he has no entitlement to do publicly what is well established he could not do one-on-one.
He doesn't have the right to try the case in public, but he has the right to speak in public about his First Amendment concerns, utilizing the First Amendment about his concerns about the DOJ.
To that witness.
I would say two things in response to that. One is that there's not mere some overlap, there's near complete overlap between the issues in the case and the issues in the political campaign.
True.
The whole statements in the case that says you can't try your case in the media are all about cases that involve influence on the jury pool. And we don't have that rationale in this case because the district court expressly rejected that.
Right,
Now,
I
am
appreciate
not
that, but
relying
what
on
about, you said
rationale.
that there's a complete overlap, but what about the portions of the order that cover the, let's say, the court's administrative staff?
Yeah, it's
There would
a
be no
Judge Engeron
reason
problem.
to campaign on any of that.
Yes,
That was
there
drawn.
is.
There was no evidence presented on that issue at all. He's never made a statement about court staff here.
So
that
that's
was
your
drawn from the
concern.
New York situation that we briefed. There was core political speech. That illustrates the hazards here. There was
Yes.
no evidence on that particular case before the district judge. Apparently, it was relying on sua sponte reviewing of media reports. When in fact, the statements about the principal law clerk in the pending New York civil trial were absolutely core political speech. They definitely violated the First Amendment.
Yep.
I'm talking about in this case.
Yeah, so this is interesting because we've covered the Engeron case ad nauseum here, and it is the judge he's making the same point that we just made in the prior segment, that the Trump defense is responding not to Tishy's arguments, but is responding to the judge's arguments, right? On their own, the court just brought it up. And that what's happening is that the clerk of the court staff, Judge Engeron's GF, the judge's Greenfield, is involved in the trial in a way that warrants comment on it, right? They want to comment on it. They are able to comment on the institution of the judiciary, not just the individual people, but the whole structure. It's all protected.
Though,
Yeah, there's
where
been no-
there's an effort prophylactically to protect court staff. And my premise is, or my question for you, is when you say there's complete overlap, it seems that that's an easy case where there actually isn't overlap. That
It's not easy. It's
individuals who
happening
are
in New
working
York.
for the judge assigned to this case would be no topic in a campaign other than an effort to undermine this case qua case.
I would say a couple of things. I think we're talking hypothetically.
Yeah,
The
we
president has
are.
never made a statement relating to this case about any court staffer that I'm aware
But
of.
the
that's
order,
ever-
as you well know, and as you've challenged, the order applies to court staff.
with no evidence to support it.
I appreciate that aspect of it, that you've made a point about whether there's evidence or not. But I'm talking about the claimed overlap between political speech and the speech that's restricted by the order. And I'm positing that there actually is speech restricted by the order that would not be campaign speech but for this case. And surely you can see that.
I think the New York decision shows exactly the opposite.
We're not talking about those circumstances. If there were a staffer of the judge about whom it became clear that there was some political bias, nobody disputes that the defendant's team could and would file a motion with the judge to raise a concern about that and comment on how the judge ruled on that. But that's not where we are. We're in a situation of prophylaxis, and that's really what I'm asking you about. A prophylactic situation where
the judge literally ordered them in New York not to file motions before relenting.
Nobody who works for the court, these are career people, nobody volunteered for this assignment, none of them have life tenure, they're just trying to do their jobs. Nothing about them would be campaign speech in the absence of a case.
But are you kidding? The law clerk donated thousands of dollars to Democrats, was running for office, was seen at rallies with Chuck Schumer, was dancing around in the streets with a bunch of Democrats. All of that is relevant and is free speech when you're talking about a political prosecution, which is what Trump is alleging. Now, you might disagree with that, but it's the First Amendment and his right to make that argument to the American people. And I happen to agree with him.
What we see in New York is that if you enter that prophylaxis now based on...
We're not in New York.
If you enter that prophylaxis now based on zero evidence, no evidence at all, no evidence of political bias might be as of the court staffers, and no evidence of any statement about any court staffers. And if it later turns out that there's an extremely biased court staffer, we have a huge First Amendment problem. We have a prior restraint based on no evidence, which is what this is.
Let me ask you that.
Prior restraint based on no evidence. No evidence. And so that is John Sauer going in and delivering the oral arguments in front of the 3 Democrat-appointed judges. And so he did a good job, right? I mean, he's in kind of the lion's dens there, and they talk a lot about causation, which I can certainly appreciate. But let's turn our attention over to Cecil VanDevender, because we got some good exchanges here. And as tough as the judges were on Trump, they were also bringing it to the government pretty aggressively. Now, this first segment's talking about whether there are direct threats, right? And this is the following the bouncing ball. Trump posts something, Jack Smith's a deranged thug, somebody gets murdered. How do we connect the 2 dots? Well, let's see what the judges say about this. This is the government presenting their case, and the Court of Appeals for the D.C. Circuit responds.
Thank you, Your Honor. May it please the court, Cecil VanDevender on behalf of the United States. The district court correctly found that the defendant's well-established practice of using his public platform to target perceived adversaries, including trial participants in this case, poses a significant and immediate risk to the fairness and integrity of these proceedings. The order that the district court crafted to address those risks should be affirmed for 3 principal reasons. First, the unique factual record before the district court. Second, the unusual narrowness of the resulting order. Third, the recent evidence demonstrating that the defendant is fully capable of understanding and applying with the order while it's in effect.
I just want to follow up. You just said significant and immediate risk. So are you not embracing the Gentile test?
No, Your Honor. To be clear, the Gentile test is the constitutional test that applies. Significant and immediate risk is the language that the district court found, so it sort of assumed that the...
Those are kind of different words.
Pardon?
Within the law, those are substantial likelihood of material prejudice and significant and immediate risk, I think, are 2 different legal tests.
So she's saying you've got this one case that has this test. Chutkan used some different words. Why did she use different words if the law says these words? Why is the difference?
Completely agree, Your Honor. And the Gentile test of substantial likelihood of material prejudice is the correct legal test. But because the district court incorporated the higher test of the defendant proffer, that is the significant and immediate risk test, I think that does inform the scope of the order and informs the findings that the district court made. But to be clear, the Gentile test is the one that applies.
Mr. VanDevender, where is the finding that you're relying on?
It's on page 2 of the order, Your Honor.
So now we're talking about the types of harm, right? Substantial, imminent, likely, all these things. If Trump says something and we follow the bouncing ball, how do we connect Trump's statements to the potential harm that we want to limit? Well, it has to have a substantial likelihood, whatever. Where's your authority for that?
The follow-on order?
Yes, this is at Joint Appendix page number 230.
Yeah, the court finds that such statements pose a significant and immediate risk.
Exactly.
That witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted, harassed, or threats. And 2, attorneys, public servants, and other court staff will themselves become targets for threats and harassment. On the second part, number 2, applying to staffs of the special counsel and of the court, the nexus between the concern that they be targets for threats and harassment and the administration of justice is not entirely apparent from the district court's order. Can you help explain that? I mean, for example, the district judge is no speech relating to the district judge is GAG.
That's correct.
And that's in part because we trust that the district judge will not be swayed by anything that the defendant says. How then could the district judge's staff affect the administration of justice?
The district judge's staff?
Yeah, any effect on them of non-criminal harassment threats?
Well, I think exposing trial participants, whether those are courtroom staff, line prosecutors, or others, to the risk of threats, harassment, intimidation poses a systemic risk to the fairness and integrity of the proceedings.
How so?
It creates a world in which people who are public servants will have to decide, handle this type of case, do I want to press on with the sort of prosecution that we think the facts and the law demand, or in doing so, will I run the risk that I will be threatened, my family will be threatened? There's a chilling effect on the
Again, if your family's threatened and all those things, those are crimes, right?
All cast over the whole.
Like the law already provides major disincentives to people to do that, is my point. I'm not saying that somebody should like be the victim and then say, well, now I get to decide whether I want to continue to work for the government or not. And then now that this is going, I'm saying the law already protects against that. Like we don't need another law to gag Trump when we already have laws that disincentivize people from calling and threatening court clerks, which I totally, seriously, like cannot make this warning enough. Text messages, phone calls, emails, anything that is even like remotely mean to an elected official, they go bananas over that, right? They absolutely go bananas. Like, oh, you're threatening my dog. You're like, no, I didn't. I just said you're doing a bad job. They're like, well, you're going to jail now. So, when Joe Biden's out there saying, text me your thoughts on my administration, it makes me very, very nervous because of that. Like we protect our public officials and court clerks. Like if you, bump into a prosecutor, they're like, oh, class 5 felony interfering with a government official. You're like, jeez Louise. Meanwhile, you can like stab and eliminate defense attorneys and they're like, well, whatever, they're like, a dime a dozen. Like they pass laws to protect themselves at higher levels than other people. The law already provides these protections. You don't need to gag Trump to do it.
If the trial participants feel like they're at risk just as a result of their participation in the case. Separately.
And that's the way you worded that. It made it sound like before they became part of the team, like in the future, other staffs might hesitate before joining the team. Is your submission also that existing staff might quit?
Well, I think there's certainly a risk of that. And certainly the court doesn't have to ask each staff member, how likely are you to quit if your family receives a death threat? I don't think there's any basis to say that in the absence of the likelihood that you will actually be deterred from doing your job, you have to tolerate threats and harassment being directed towards trial participants.
I had just a sort of very specific question. You mentioned the families, and the district court from the bench said that the gag order applied to the families of the staff of the court and the prosecution and the defense counsel, but the written order doesn't reference that provision. But what is the government's position as to whether the order currently applies to family members?
Our position is that it does, Your Honor, for two reasons. First, the beginning of the order, of course, incorporates the oral explanation. Okay. And as the court said orally, the prohibition on targeting family members, in her words, goes without saying. And so I think in district court's view, because the prohibition extends to these specific categories of trial participants, it necessarily extends to their family members as well.
So as I take it, your position is less a substantive one, that it would affect their impartiality, but is more a question of whether the people would even be willing and able to do the work.
It's partially that it would threaten whether they're willing and able to do the work. Could also threaten the way that they are perceived by the jury. I know that my friend on the other side had suggested that the district court disavowed any sort of jury taint as a rationale for this order, but I disagree with that. What the district court did disavow was the request by the government to include within the scope of the order post-targeting the jury pool in the District of Columbia, said that can be dealt with through voir dire. I'm not going to prohibit those statements, but I think the district court very much incorporated the idea of trying the case in the media, polluting the jury pool, prejudicing the jury. If the case is presented to the jury by people about whom there's been a months-long persistent drumbeat about their corruption, inflammatory comments about them in the public, that could affect how the jury perceives them.
Wow, pretty amazing, right? It could impact how the jury perceives the prosecutors if they show up and there's this onslaught, right? There's this consistent drumbeat of Jack Smith's a deranged thug. Molly's the highlighter queen of the DOJ. Jay Bratt, we'll leave that one. We've got a lot of other things, right, that we continually hear from Trump and a bunch of people on the right calling him all sorts of bad names. And that's going to cause justice to be improperly administered. Well, isn't that curious that the other side can do this? Do you think that there is just the other side saying nice things about Trump? Trump's a pretty decent guy all day, right? No, everywhere you turn, every single person in the media, mainstream media, all of the DOJ's friends out there at the Washington Post, the New York Times, all of the political candidates running against Trump, people like Chris Christie, all these guys showing up. Trump's got 91 felonies. Trump's got 4 different indictments. Everywhere you turn, right? It's the same broken record time and time again. Do you think, Mr. DOJ prosecutor, that the jury's going to show up and just be tabula rasa there, blank slate, after they've heard that for the last 3 years, that Trump is an insurrectionist? But no, he's more concerned about Jack Smith's reputation being damaged because Trump, who has a fraction of the megaphone that the rest of the media has, is hurting Jack Smith's credibility. Give me a break. And so now we've got a long exchange here, but quite a good one, are kind of addressing this causation issue. And I want to spend some time on this because this, again, is the government prosecutor and the Court of Appeals for the DC Circuit.
How do we know what he gets held accountable for? I mean, this is the internet era. He's a high-profile public figure who posts lots and lots and lots of followers.
True.
But it's also covered on news channels that have listeners and
writers,
newspapers that have readers, and all manner of media can communicate his words to people of the public. How does a district court reasonably decide which postings he is responsible for prompting adverse conduct, resulting in adverse conduct, and which are he's expressing his views, as the First Amendment allows, and in a social media world cannot be held responsible for everyone anywhere in the United States does when they hear about it?
Two answers to that, Your Honor. I think first is the sheer number number of occurrences. So certainly if there had been one time when he posted something derogatory about a person and then at some point thereafter that person was a recipient of a threat, I don't think we would be here. The sheer number combined with the testimony of the people who experienced it on the receiving end who said what changed when the defendant tweeted about me was I started getting much more graphic, much more specific, much more pervasive threats. When, as one of the witnesses, a poll worker in Georgia testified to Congress.
Do you have any of that with respect to his statements about this criminal trial?
No, none of the people who have been directly threatened as a result of this criminal trial have testified about that exact phenomenon. Although, again, I think the context around the threat to the district court is worth emphasizing. So the indictment came down on August 1st. The arraignment was on August 3rd. Before traveling to the arraignment, he issued a public statement saying, unfair venue, unfair judge. The next day, he posted, go after me, I'm coming after you. And the day after that, the district court received the death threat. So, yes, it's a matter of inference, circumstantial evidence, of course, but the district court made those findings. And to Judge Pillard's point earlier, those are findings of historical fact that should be reviewed for clear error.
Okay, so he is saying that the phone call that we heard about from the last clip where Trump's defense attorney was saying that was an alcoholic who was sitting on her couch, who watches the news, who doesn't even listen to social media. She just made a phone call in a drunken stupor to the judge and said some things, and she's already being prosecuted. In fact, there was a probable cause statement and they've gone after her. Dad says she just sits there on the couch all day and makes phone calls. But he says, yeah, but Judge Chutkan blamed Trump for that. And you see what they did? These sneaky prosecutors, very dishonest, is they tied it timeliness to the time, to the calendar dates. Indictment came, arraignment came, Trump made a statement, and they just scoured, okay? They were going through Judge Chutkan's text messages, her emails, her phone calls, and they're like, did you get anything? Did somebody cut you off on the way home, Judge Chutkan? Was somebody mean to you at the grocery store? Did they steal your parking lot? Oh, okay, so that's an attack on you. We're gonna blame Trump for that, and they did, essentially. And so he's reiterating that. He says, Your Honors, Court of Appeals, I can't debate that, really. Judge Chutkan put that in her findings of fact, even though it's not a real legitimate threat caused by Trump. No causation there.
And because I know you referred us to the district court on page JA85. Special counsel has been subject to multiple threats. That's one thing. But the special counsel's office has been targeted through inflammatory public posts. I guess intimidating communications and then inflammatory public posts. But doesn't the First Amendment protect, and this is, to be clear, these comments have come in the course of a presidential campaign, or I guess at this point a party nomination campaign. Yeah. Inflammatory language?
So, Your Honor, our position...
Surely there has, I asked them about balance for protecting the criminal process, but I guess I'm asking your position, which doesn't seem to give much balance at all to the First Amendment's vigorous protection of political speech. And the notion that high-profile public figures or governmental officials who take on enormous responsibility like prosecutors can't stand up to some inflammatory language seems to me to contradict Supreme Court precedent and seems to me sort of a very troubling lack of balance on the free speech side on the part of the prosecution in this case.
Oh, yeah, she's right. It seems interesting that these government prosecutors can't stand up to some inflammatory language. They can't get it together. Oh, they called me a highlighter girl. Oh, no, because I'm a deranged thug. Oh, no, I'm so pained by this. I can't handle it.
Our position, Your Honor, is not that these statements in a vacuum are unprotected. It's that Gentile presupposes that the restricted language is protected, as Justice Kennedy said there. That was classic political speech directed towards the government. Nevertheless, it can be proscribed if there's essential or likelihood of material prejudice to the proceedings.
How do inflammatory posts about the special prosecutor create a substantial threat of material prejudice to the proceeding?
So that's what I think we tied back to the record, which is that there's a pattern, there's a dynamic. It's very clear that when the defendant engaged in repeated inflammatory personal attacks on someone, there's a causal link between that person then receiving harassment, threats, and intimidation. And as I was...
Well, there's actual threats, then that's a crime, and that can be dealt with.
Yes,
but
if it's short of that, if it's, again, we had Fifth and Sixth Circuit cases, and if you've got someone who says that prosecutor's out to get me, that I think there were allegations the prosecutor's racist in one of the cases, this is all a political vendetta. Are those things allowed? They're pretty inflammatory.
Well,
calling someone a racist is pretty inflammatory.
Yes, Your Honor. The district court tried to craft a very narrow order that allows some ample room to criticize the prosecution as political.
How does it do that if you say you can't target the special counsel?
Well, the district court, I think, draws a very clear distinction between attacking institutions and processes on the one hand and attacking individual trial participants on the other. So saying that the prosecution is politically motivated.
The prosecution is a governmental institution. It's not a personal job. It is the government, right? When the prosecution speaks, even when it's an independent counsel, they speak for the United States government. So I'm not sure that line works so well.
No, that's absolutely right. Maybe I wasn't clear. What I'm saying is attacks on the prosecution, calling it unfair, calling it politically motivated, those are all fair game.
But you can't say the prosecutor is politically motivated. That would certainly count as targeting the prosecutor.
I think the special counsel himself is a somewhat unique case because he is both an individual trial participant and very much represents the institutional interests of the Department of Justice. So for him, we would concede that merely kind of referencing him or criticizing him.
The prosecutors working with him and under his supervision, you can't say they're politically motivated?
If you're talking about about individual line prosecutors, particularly if you're mentioning them by name, then no, the mechanism for that, as Judge Pillard alluded to, is file a motion. Certainly if you think that there's some political bias.
Is to file a motion every single time he wants to say all the prosecutors in the office are politically biased against me?
To be clear,
I mean, it might not be true factually, who knows? But I'm not suggesting that it is. It's just a question. But if in his mind, in his view, all the prosecutors in the office are politically biased against me, he has to file a motion before he can say that? That's not taking much account of the First Amendment interests at stake.
Well, I think if it's at such a high level of generality, everyone...
How can you tell that from this order? That's definitely targeting folks in the special counsel's office. So it's definitely prohibited. So I think that's why you're saying he has to go file a motion to make sure he's allowed to say that.
Well, the motion I'm alluding to, Your Honor, is not a motion to ask for permission to speak about it. What I'm talking about is avoiding a two-track process here, where there are claims that get presented in court and then a whole separate effort to kind of malign the people involved, suggest that there's some improper purpose or motivation or bias that's never even raised with the court.
That is literally what they're doing against Trump every day, okay? Liz Cheney had 8 hearings on it.
The defendant is free, of course, if he thinks that there's a colorable claim of prosecutorial misconduct or prejudice, likewise judicial, to file a motion seeking disqualification, dismissal, and then he can talk about the fact that those findings or filings exist. But what he can't do is say, I'm going to have this churning narrative that there is political bias, but I've never presented it to the court.
But so imagine, I understand he hasn't participated in debates thus far, but if he were to choose to participate in a debate and the other folks who are competing for the Republican nomination, let's just say they spend a lot of time talking about, you're an indicted felon, you're being prosecuted by the United States government.
Christie does.
They'll prognosticate you're going to, you could be found to be a criminal before the election, and they have all this evidence against you, the millions of pages that they talk about in the record here. And so they're going on and on and on during the debate about this criminal prosecution. And you're telling me he can't say,
nope, not unless he checks
public record prosecutors paid by the taxpayers, your names are public record, A, B, and C prosecutors. It's all a political vendetta. They all are doing the bidding of Joe Biden. Yeah, I'm not saying anything's true here. I'm just saying that's not the test for free speech in this country, thankfully. He can't stand on the stage and say that.
So, Your Honor, he can certainly say this is a politically motivated prosecution brought by my political opponent. The Department of Justice is corrupt. I will be vindicated at trial, all of that stuff. But when he starts naming
he has to speak Miss Manners while everyone else is throwing targets at him.
Yes, Judge.
Well, and it can't be that he can't mention Mr.
He has to speak Miss Manners. He has to say, well, everybody, the DOJ as an institution's corrupt, but the people who are prosecuting me, I really can't comment on because the government has their fifis hurt. Come on. Judge is on the money with this one.
Who, for most people in the United States, given the number of legal battles in which this defendant is embroiled, the easiest way people have of referring to this case as opposed to the others is Jack Smith. Surely he has a thick enough skin. He's on this team. The two interests that you mentioned, which are one, the person would be dissuaded, little doubt that he will not be dissuaded. And then the other, that his impartiality or integrity would be impugned in the face of the jury. I'm not sure I see the district court having made any such determination or even followed that reasoning. Am I missing something supportive of that link?
Well, it's very clear that the district court is, because the whole rationale is premised on ensuring the integrity of the proceedings and the fairness of the trial, of course the court wants to make sure that the jury is not presented with extraneous information that would not be admissible in court that could prejudice their determinations. And I think part and parcel of that is how they view the trial participants. But
the jury needs to be protected from extraneous information. So Trump cannot speak. But is there any gag order for the media? Like, should they be blacking out the media in Washington, D.C. for the prospective jury pool? Because they don't want them to be biased, right? In other words, the same things, they would obviously deny that. They'd say, we fixed that in voir dire, because they do. Did you hear anything about this case? Yeah, I've been following it all day. Okay, do you have any opinions on this matter? Can you be fair and impartial? No, I can't. That Trump is guilty. Okay, well, you're not going to be a good juror. Or, I heard a little bit about it. Can you set that all aside and be fair and impartial? Yes, I can. Sure, yeah, I'm a good Democrat. I'm happy to play this stupid game here in D.C. Yeah, I'll be fair and impartial in my Trump trial. Put me in, coach. But with Trump, they can't do that. They say, hey, Mr. Juror, have you heard Trump call Jack Smith a deranged thug? Have you heard Watching the Watchers call Molly highlighter girl? Yeah, I have. Can you set that aside and be fair and impartial? They could ask the same question, but they're not. They just turn around and gag Trump. Now, Trump can't talk about that. We have to gag him. Meanwhile, everybody else has free reign.
But to go back to...
How can, I guess Judge Millett has already asked these questions. Given all of the issues that are both before the court in this case and before the public in the election, it's hard to see how this portion of the restrictive order is going to succeed in preventing a trial in the court of public opinions. I took her order to more be focused on protecting individuals, protecting witnesses from threats, from harassment, from, fawning and efforts to positively motivate them and the like, not to shield the veneer. But you take a different view.
Well, no, I think I would agree that that is the principal motivation, certainly shielding people from harassment, threats, and intimidation, both witnesses and other trial participants. And certainly that includes, the line prosecutors handling the case. Again, special counsel himself is a slightly different case because he is both an individual trial participant and a representative of the institution. And so that's why we would say that merely mentioning him would not violate the order. That would not be targeted. Whereas in the debate, Your Honor, if...
I do want to hear that answer. I was going to ask a question, but before I do, I'm still struggling with how you distinguish. I mean, maybe the special prosecutor is in a somewhat different place, but that does not mean that prosecutors working with him, assistant prosecutors, or whatever the title deputies, are not public figures themselves.
They are.
Would you agree?
They can be public figures for certain purposes.
Okay, so then it shouldn't matter. Why can't, on the debate stage, and I guess now you can do that answer on the debate stage, why can't the defendant say A, B, and C, whoever is prosecutorial team in the particular case,
Molly
biased,
and Jay.
racist, anti-American,
They are.
whatever deplorable adjectives.
I think in context,
Yeah.
I think you'd have to view that as basically the meddlesome priest problem.
Partisan,
Why is he mentioning individual line prosecutors, but for holding them up to scorn in the public and increasing the likelihood of their
Well, I
being
have to
targeted?
say they make a good point.
They do.
That I'm not sure that will no one rid me of this meddlesome priests might not have a more First Amendment debate. You'd have to really make the showing.
Prove that.
If it's sort of the Godfather.
Prove it.
Someone get rid of the snitch for me, that's one thing. But you'd have to make that kind of showing.
High
But,
standard.
if someone high up says, well, someone just make this problem go away, could he not say, well, someone just make these cases go away? It's a political vendetta.
Can he
Let
say
the
that?
American people decide.
Of course he
Can
can
he
say
not
that.
say that?
Someone make these cases go away, the civil vendetta, that would be consistent with the order. That would not violate it, yes.
Not violent.
So tell me about your debate, what your view of, it would be really hard in a debate when everyone else is going at you full bore.
So someone says Trump is violating the law from Jack Smith's office, because he says somebody get rid of these cases. Somebody eliminate these cases. Just like Dan Goldman, a Democrat congressman from New York, said the same thing about Trump. Eliminate Trump, right? Can Trump say those things? And he kind of concedes that he could. Well, then what is illegal then, Mr. Prosecutor? What then is the problem that violates the order that would subject Trump to sanctions and contempt under court?
And, your attorneys will have to have scripted little things that you can say.
Your Honor, I respectfully disagree that there be anything particularly challenging about a rule that says naming individual line prosecutors somehow, is too complicated, too hard to follow. He can say everything he wants
You
to
don't
say.
think you can name line prosecutors by name?
I think that would be presumptively an act of targeting. Context could suggest otherwise, but naming...
Well, what context do you need? I've got my debate here.
Yeah.
Matter of public record, you're receiving the pay of, you're paid by the taxpayers, and he can't say by name that person?
Even once you've appeared and spoken in open court in the case against him.
Our view is that is presumptively targeting within the meaning of the order, but...
It's targeting because you're not the special counsel.
That's right. It's targeting because...
What's your definition of target?
Targeting, in our view, means singling someone out for the sort of negative attention that poses a significant immediate risk of their being recipient of threats, harassment,
But
intimidation.
negative is viewpoint-based, so the district court corrected. The reason she chose targeting instead of the language that you proposed was because you didn't want to make the order viewpoint-based and make it more defensible. But I think you're right that the targeting does raise a little bit of unclarity. And I wonder whether you comment on the proposed alternative that I mentioned to Mr. Sauer, which is if the order prohibited comment on any reasonably foreseeable witness or the court staff, but let me limit it to the witnesses, reasonably foreseeable witness because of witnesses' potential participation in the trial. Because one of the difficulties is disaggregating the public figures who are in the political arena in other ways, writing books or, and who are anticipated to testify at trial here. Does that do the work that you need? Does it pose different constitutional concerns that I'm not appreciating?
I don't think it poses any additional constitutional concerns. I think that would be a perfectly valid gloss on that portion of targeting. I do think it omits another important component, which is this concern about exposing people to threats, harassment, intimidation. So if the defendant were to say, not with any reference to their testimony, but say this person, is a coward, a liar, and a treason and deserves a punishment of death, without any reference to what the substance of the testimony would be, I think that would still violate the order.
Except couldn't you, given context, if there's no other reason that this person is being targeted, you say the reason they're talking about that is because of the testimony. Whereas, when General Millett has written a book and has spoken publicly about his efforts to shield the world from the consequences of the defendant's conduct, that has got to be fair game.
Certainly fair game to comment on it. No, I don't think anybody suggests otherwise. But I think it's...
So what's not fair game? So he can comment.
Yes.
And he can comment very critically. What can he not do?
Use the sort of inflammatory language that poses a significant risk that they will be subject to threats, harassment, and intimidation. So
he can totally comment on it. He just can't say anything that's meaningful. Okay, he can say something about it, probably like Mark Milley's amazing, and Mark Milley's like an American hero, and everything in his book is accurate. But if he says anything else that might be inflammatory, like anything, like Mark Milley's wrong, Mark Milley is incorrect, Mark Milley is a moron, Mark Milley is a traitor, like obviously those things might be factual, but he's going to say they're all inflammatory. Mark Milley's opinion is in disagreement with my opinion. Like what?
Like this by the chairman of the Joint Chiefs of Staff is intolerable in democratic society, and saying, on the other hand, this warrants the punishment of death is a particularly abstract or difficult line to draw.
So it's comments that will predictably trigger the loyalist zeal zeal, or what Mr. Sauer refers to as the heckler's veto. And that just took me a long time to figure out what he was referring to in terms of heckler's veto, but it's the triggering third-party conduct.
Read the brief, Judge?
What I would
it's in the brief.
tag as the loyalist zeal. That's what you're aiming at, is that the defendant can comment on all kinds of things, but when he does so in a way likely to trigger this excessive zeal, that is what how you read the district court is targeting.
I'm full of zeal, man. I got a lot of zeal.
Barring that kind of speech.
Yes, right. And going back, Judge Millett, going back to the question about what can he say during the debate. I mean, I think it's also worth looking at some of the things that he said in TV interviews, and even in one of the posts that the district court used as an example in order denying the motion to stay of what's permissible. So in that post, he's talking about the political bias in this prosecution, how it's been brought by the incumbent administration, and he says, at trial we will 100% prove with evidence that I won the election and so forth. He can always say what every other criminal defendant in every other case says. Once we get to trial, I'm going to prove all this with evidence. The necessity to single out trial participants that have not been the subject of any sort of litigation, just as sort of a personal singling out just to put their name in the public, I think is presumptively an active target.
So if I'm on J130, which is the General Milley post, can you tell me which parts of that, because this was the day after General Milley did an interview about his book. It wasn't right after the indictment. It says nothing about the criminal trial or General Milley's prospective role or not in it. So tell me, what of this, is everything okay except the punishment would have been death? Is everything else okay?
Yes, I would say so, and I think the important context to know when reviewing...
Is he wrong? Not talking factually about this particular situation, about which obviously we have none of the details before us.
Well,
but is it wrong, at least historically, that, again, not talking about this conduct in particular, but some acts of treason were punishable by death?
No, that's not wrong, and the district court was free to...
Isn't that all he said?
The district court was free to decide whether he included that language to make kind of the abstract historical point about what punishment for treason was in times gone by, or was he saying it to...
Well, what do you, I think...
To make a point. He's allowed to make a
talked at least
point.
about the need to balance, and, it's not how I want my children to speak, but that's really not the question. And so the question is, what in here in this post, including the reference to historical capital punishment for treason, connects that to the criminal trial? Connects anything about this post to the criminal trial, the criminal process, General Milley's potential or not, I have no idea, participation in the criminal trial?
So on its face, it doesn't allude to his testimony, but it's important
the
to...
timing, you don't have the timing. It's not like the time.
We do have an important distinction in timing, is that the information about General Milley and his conversations with China, that all came out in 2021. The defendant had a reaction to that news then. He was not calling for him to be put to death, suggesting that death was an appropriate punishment. He started doing that once he was indicted.
Wasn't this the day after General Milley did an interview about his book?
Yes.
Okay.
So it was in the news again, but his reaction to it, post-indictment, once he knew that General Milley was a potential trial witness, was very different than what his reaction was in 2021 when General Milley was not a potential trial witness against him. And so
pretty much once there's an indictment, he just really can't say anything
Bingo.
about folks who are either known or reasonably foreseeable witnesses.
Bingo, the judge just nailed it, right? The indictments freeze the playing field. Everything gets stopped. So they file it. Now Trump can't say anything. Now everybody else can't say anything. An investigation's ongoing until the charges come. And then now it's to protect the sanctity of the courts. So now Trump has to be gagged. And now none of these witnesses can be involved. And now everybody's freaked out that they might be indicted next. And so the whole game gets frozen and they can lay up trial after trial after trial. And they can fight for gags in every one of them. It's by design. Judge just nailed it. Yeah, no, exactly right. You can't comment on anybody. Milley, Pence, Pelosi, a whole reasonable panoply of different potential witnesses, reasonably foreseeable witnesses are all brought into the fold. Trump is neutralized, essentially, and that's by design.
I disagree. I think
Can you say?
There's a perfectly comprehensible line between the sorts of things that use inflammatory and disparaging language that are likely...
Can you say anything disparaging about someone? You just said inflammatory, disparaging. So take off inflammatory.
How about disparaging?
Is he allowed to say anything disparaging about someone? We'll make it easy that he knows
Pull on that
going to
string.
be a witness now that there's been an indictment. Between now and the trial, obviously after trial is a different thing.
I think he can criticize them so long as he's not using either inflammatory language or attacking their credibility in a way that's going to shape how the jury sees them.
He can criticize them without attacking their credibility. How do you do that? Does anybody know how to do that? Wow, gosh, I mean, I think Jack Smith has a great case, but has bad judgment. I think Jack Smith is... How do you criticize somebody without attacking their credibility? Jack Smith's ugly? Because if you call him deranged, well, it's his credibility. Anything, like literally, like anything that's a commentary on his performance is a criticism that attacks his credibility, isn't it? And he says you can't do that.
That's another example of trying the case in the media.
I'm trying to understand with respect to these high public figures, they, like everyone else in the country, are protected against true threats. They're protected against criminal efforts to affect their testimony. They can be prosecuted for that. The defendant could be prosecuted for threatening them in violation of the criminal law. But when we step back and think about a protective order to protect the integrity of the proceeding, the mechanism is their testimony would be affected. That's very hard for me to imagine.
I don't think that the test is whether any particular witness who is targeted will actually change their testimony or refuse to
or
testify.
that it would be reasonably foreseeable that, you're right, this is a prophylactic situation.
Gagging him,
I would assume that their testimony would not be affected, that Mr. Barr, General Milley, former Vice President Pence. I take part of your position to be that there's a performance of their vulnerability liability that then would affect unknown non-public figure witnesses?
That's exactly right. There's a clear kind of knock-on effect. If you're a witness out there, and there are many witnesses who fall in this category, not public officials, no recourse to marshals or Secret Service protection. If they see that General Millett can be suggested he should be put to death, if they see the former chief of staff can be called a coward, then they are going to absolutely be chilled. They say, why would I come forward and give the facts that I know about this case if the result is going to be that I'll be subject to the same treatment?
This is a very small question, and it reveals my lack of technical prowess, but is there any way preventatively to protect someone's technology? Like, let's say I'm a prospective juror. Can I be protected technologically from, like, doxing?
No, you could have CISA and the old X, old Twitter censor you or something like that, Judge. But no, you can't censor a bunch of people. You can try to gag the president, which is what you're going to attempt to do. But my friends, that is really what happened. And I thought it was nice on the flip side on that to hear the judges, even the Obama appointed judges, kind of lacing into the government. How do we measure this? First of all, how can you connect Trump's statements to any actual harm? And the things that he says, aren't they kind of true in some instances? And can he say those things? And this government prosecutor had a real difficult time, I think, trying to tease out what the standard is. He says, no, he can't say anything that's inflammatory. Well, how do you criticize somebody without being inflammatory? It's kind of an impossible thing to do. So they're having a difficult time there. Now, we're still in front of 3 different judges who are all Democrat appointees, Obama appointees, Biden appointees, but the First Amendment is written pretty aggressively with a lot of historical precedent to support it. So we'll see what they do. My estimate is that they'll probably uphold some portions of it, maybe get rid of some other portions of it, but my guess is that regardless of what happens, this is just a temporary stop on the way to the Supreme Court. I think that regardless of the outcome, one side or the other will be appealing this up to SCOTUS, and then we'll have a final say that might impact the rest of the country. We'll see when it comes out, whether they accept the case, whether this happens before March, whether Trump is going to be limited in his free speech rights during the pendency of this trial or not is yet to be seen, but they're fighting hard. We'll be here to continue to cover it, my friends. Thank you for subscribing. Thank you for liking this video. Thank you for really inviting somebody to come over here and join us on our live streams. We go live weekdays. We'd love to have people come and see what's happening behind the scenes on these cases, because the media, it's just surface level stuff. They write an article. There's no real documents. They just kind of give you the headlines that they want people to believe. And we're trying to show everybody what really is happening behind the scenes here. And so thank you for inviting people to come and join us. Just invite them to subscribe, and we'll look forward to seeing you and them on the next one.